imposed on the tavern owner, even if the tavern owner has actual knowledge of intoxication?
Your Honor, under the Indiana Court of Appeals holding in Fast Eddie's, it says that when there is a willful, wanton, criminal, and malicious act, it is, as a matter of law, a superseding, intervening cause.
Well, willful, wanton, malicious criminal act is more than just criminal, right? So is your standard criminal, or is it willful, wanton, malicious, and criminal?
The standard we assert here is criminal, but the Indiana Court of Appeals...
Well, if your standard you assert is criminal, is there ever going to be a case, given how strict our drunk driving laws are, is there ever going to be a case where the behavior is not criminal?
Judge Sullivan, I believe you're referring to a criminal act as far as intoxicated driving.
Right. Well, tell me how that's different from what you're referring to as criminal.
Your Honor, essentially, if the criminal offense of driving while intoxicated alone were sufficient for the issue of the Dram Shop Act, then there would never be any defense for any bartender who had a person who was in a vehicle with the collision, such as here. But as Fast Eddie says, when there is a willful, malicious intent to cause harm, as there is here, which is evidenced by the overwhelming circumstances of the case, it is as a
summarize what those facts are.
Gladly, Judge Alexander. From the beginning in 2006, when Mrs. White broke up with Mr. Hart, he immediately showed signs of anger, resentment, and jealousy, namely pulling out his hair, losing his temper, yelling. It was only after this point that he started to drink heavily, according to the record. And it was after this point that he started drinking heavily that he got his first OWI. Furthermore, again, it's also important to look at the minor fact that Mr. Hart had this woman's name tattooed on his arm. Never, even after she broke up with him, he never hid it or tried to hide the fact that he still cared deeply about this person. A time after, when he learned of the fact that his ex-fiancée, the woman he still loved, was going to marry another man, he said, "She should be my wife," and got in a physical altercation where he tried to criminally assault and attempt to punch Mr. Bruno White.
Is it your theory that he was trying to run him over with a car, deliberately crashed his car into him?
Yes,
Is that
Judge
what
Perry.
You need for an intervening cause?
Judge Perry, what the defense needs for an intervening cause is evidence of a willful, wanton criminal act.
Well, Counselor, what do you do with Mr. Hard's testimony to the effect that he doesn't remember anything about it? So he couldn't have had the intent to do that, could he? He doesn't even remember it?
Judge Turk, the simple fact that he doesn't remember anything about the nights, it clearly evidences his intoxication, but it does not delineate the fact that he did intend to cause the harm, which is also further evidenced by the overwhelming evidence leading up to this night.
Well, Mr. Mader, the facts of this case are quite clear from the 9/11 transcript. He was already on the wrong side of the road when the Whites turned their vehicle in front of him.
Yes, Judge Yates. When Mr. Hart was on essentially the same path that the Whites was on. This again, I'd like to preface my answer with the chronological events that led up to that. Mr. Hart, again, having drank in an unusual manner because the Whites were there. When they left, he said, "She should be my wife." Again, tried to punch Mr. White, and not succeeding because he fell. He continued on to his car, where he managed to turn on the ignition and careen out of the parking lot recklessly, hitting things left and right, but with one thing in mind.
But your response to Judge Perot's question was that he intended to hit the side of their vehicle. He was already on that side of the road when they turned in front of him. By the transcript from Miss White, as she was on the phone with the operator to 911, her own testimony was he was on the wrong side of the road.
Yes, Judge Jason. My response to Judge Turk's question was that he intended to cause harm to Mr. White, and in so doing, intended to cause the harm which resulted from this collision, which he intended to do. Essentially, Your Honors, we have what we have here. When he left the bar, he said, "This is not over yet," which creates a continuous and future threat of harm to the plaintiffs. He recklessly sped out of the parking lot after, in pursuit of the plaintiffs. The plaintiff herself says in her 911 dispatch call, "He's chasing us, he's chasing us, he's chasing us, please send help."
Well, what's relevant here, right, is his intent, right? Not what she thinks his intent is, right?
Yes,
if you're going to establish this criminal act.
Yes.
Now, under Indiana law, can an intoxicated person have the requisite intent to commit a crime?
Yes, Judge Sullivan. The Indiana Court of Appeals in Welsh has held, and also in Fast Eddie's, that when there's evidence of criminal intent, the simple fact that he was intoxicated is irrelevant. When the intent would have been there, with or without intoxication, the intoxication itself is not a proximate cause of the injury.
But you would agree, would you not, that in the Fast Eddie's case, it's a lot easier to see the crime there because you have an assailant pulling somebody out of a car and shooting them. Clearly easy to determine that's a criminal act as opposed to here where somebody's running into a car making a left-hand turn. Looks like Fast Eddie's is an easy case to find a criminal act because they shot him, as opposed to somebody in a car that's on the wrong side of a road that runs into a car that makes a left-hand turn.
Yes, Judge Burnett, and I understand your concern about the nature of the instrumentality of the crime. But as Welch has also held, the Indiana Court of Appeals in Welch has said that the instrumentality of a crime does not matter because a person who wants to commit a crime, as Mr. Harv did, will find a way to do it. And the instrumentality is not relevant. Furthermore, he did not succeed when he tried to punch Mr. White at the bar. He continued into his car, followed Mr. White, and recklessly, remember, Your Honors, he had one thing in mind here, and that was to cause harm to Mr. White, which is evidence from the overwhelming weight of the facts from the
Did
beginning.
Mr. White give a left turn signal?
Your Honor, I don't think that, I honestly don't remember from the fact that he did.
Now, Mr. Van Meter, it's your view that he's still in love with Debbie White?
Yes, Judge Sullivan.
So if he's still in love with Debbie White, isn't it counterintuitive to think that he's going to ram his car at however fast he was driving into a vehicle in which she's riding?
No, Judge Sullivan, because he wanted to cause harm to Mr. White, the man who married the woman that he loved. And still, he was also angry at the entire situation, which Ms. White obviously played a role in. And essentially, Your Honors, he did not necessarily have to intend to kill Mr. White or injure Ms. White to the point that he did.
You don't think that you can draw a reasonable inference from these facts that this wasn't intentional? I mean, the whole predicate here is that you say that he's mad at Mr. White because of his love for her, but isn't there an equally strong inference that this couldn't have been intentional because of her love for her? That is to say, he wouldn't be running his car into a car that she's riding in if he loves her?
No, Judge Sullivan, and here's why. To do so would be to peer in the mind of a criminal, which as a matter of general public policy is not appropriate. Furthermore,
well, how do we determine his intent without peering into his mind?
Because Judge Sullivan, the intent is evidenced by the overwhelming weight of the facts of this case. So essentially, you have a chronological development of a building anxiety and resentment, animosity and anger towards Mr. White, who again married the woman that he loved and thinks he should be with.
Are you saying only a single conclusion can be drawn from these facts?
In light,
Isn't that required in Fast Eddie's for summary judgment?
yes, Judge Gamble, and also in Booker,
But how can there be a single conclusion when he was bouncing off cars and already as intoxicated drivers are wont to do, driving in the left lane and that sort of thing? Can't we draw a different conclusion? He was just intoxicated.
No, Judge Gamble, because when we look at the totality of the circumstances in this case, the simple fact that he hit things on the way out, which we assert was because he had one reckless goal in mind, which is cause harm to the plaintiff, nothing which would get in his way. Even if it could be inferred that those accidents happened because he was intoxicated, it does not mean that he didn't, as is evidence, continue on a straight path in the same direction as the Whites were traveling. And as he approached them, having, again, a continual and a future threat to cause harm, wherever they went, when they turned left in front of him, he did not slow down. He did not turn left or right. He took the opportunity that was in front of him and hit them dead on.
Wasn't that just merely consistent with the way he'd been driving all along? You don't think he intended to wreck his car when he left the parking lot, but he did hit things in the parking lot.
Yes, Judge Moon. And again, we assert that the reason he hit these things is, again, because he had one thing in mind, which was to cause harm to Mr. White, and that nothing was going to get in his way, cars, curbs, or mailboxes. But even if we assume that those were results of his mere intoxication, it does not mean that he did not still continue on the same path as the Whites, following them to the point where Miss White called 911 and said, "He's chasing us. Please send help."
Mr. Van Meter, doesn't the record indicate that Mr. Hard and the Whites had been in the tavern on a number of occasions in the past?
Yes, Judge Sullivan.
And so why this without any apparent incident?
No, Judge Sullivan. There's evidence in the record that at O'Malley's Tavern, when Mr. Hard learned of Mr. White engaging his ex-fiancee, it's the first sober, mind you, altercation between the two. It was then that when he learned of Mr. White marrying his ex-fiancee, he said, she should be my wife. And he tried to punch Mr. Bruno to the point where they had to be physically separated to prevent further violence. So there's evidence, Your Honors, here from both prior
But
and
he
here.
apologized for that, hadn't he, later on?
Yes,
And so they invited him to the wedding?
yes,
Didn't show, but they invited him, did they not?
yes, Judge Turk. And as you pointed out, he did not show, did not even send a reply, obviously because he was still not okay with this whole situation. And the simple fact that he was
Did
cordial,
he send a wedding gift?
it's not stipulated in the record.
Mr. Van Mater, I try to be a little more conscious of our time here. I see that the red light is on. I want to make sure that my colleagues don't have any further questions for you. I do have one more. You've been quoting the Fast Eddie case and the Welch case to us, and you've told us those are cases of the Indiana Court of Appeals. Now, the Indiana Court of Appeals is not the court of last resort in Indiana, and I wonder if you have any authority for us on these propositions from the Indiana Supreme Court.
No, Judge Sullivan, I do not at this time.
And do you know if the losing parties in either the Fast Eddie's case or the Welch case sought review by the Indiana Supreme Court of those decisions?
Could you repeat your question, sir?
If the loser in the Indiana Court of Appeals has the opportunity to ask the Indiana Supreme Court to review that decision, sometimes the Indiana Supreme Court does, sometimes it doesn't. Sometimes we can draw an inference from the fact that review has been sought but denied that the Supreme Court may agree or at least not strongly disagree with the decision of the Court of Appeals. Are you able to tell us whether the loser in the Fast Eddie case or the Welch case sought Supreme Court review?
Judge Sullivan, I am not.
Thank you. Any further questions? Thank you, Mr. Van Mater. We'll have 2 minutes for your rebuttal, unless you want to take a second to sum up?
If you will.
Yeah, go ahead.
Your Honors, again, the facts of this case do lead to only one reasonable conclusion, and which is evidence from the overwhelming weight of the chronological sequences of events which happened from the beginning of this whole story until now. Mr. Hard had a vendetta, an angry, jealous vendetta against Mr. White. He intended to cause harm, and he did. He succeeded in his goal, which is why, and again, as such, this was a criminal act which is a superseding, intervening cause above all other proximate causes, which as a matter of law bars the plaintiff from recovery, and which essentially makes our defendant entitled to summary judgment. Thank you.
Thank you, Mr. Van Mater. Next, we'll hear from counsel for the plaintiffs, Mr. Walsh. Fifteen minutes or thereabouts, Mr. Walsh.
Yes, Your Honor. Your Honors, and may it please the Court,
I
my name is...
assume that neither of the counsel for the appellant convinced you that Ms. White doesn't have a case.
No, Your Honor,
Okay.
absolutely not. May it please the Court, my name is Jackson Walsh, and I, along with my co-counsel Amanda Babbitt, represent the plaintiff, Deborah White. Your Honors, I will present the issue of actual knowledge. My co-counsel will present the issue of proximate cause. The Court should deny the defendant's motion for summary judgment for the following two reasons. First, Indiana courts have held that when a jury can reasonably infer from the evidence and circumstances of the case more than one conclusion, more than one reasonable inference, summary judgment is inappropriate. And second, in this case, the jury could reasonably infer that John Daniels had actual knowledge of the visible intoxication